I have been a judge for over 30 years. I have seen fraud, manipulation, and betrayal in every shape imaginable. But when Harold Bennett walked into my courtroom that morning, slowly, carefully, like a man who had learned not to trust the ground beneath his feet, I knew this case was going to be different. He was 71 years old, retired construction foreman, built his business from nothing. No loans, no investors, no shortcuts. Just 40 years of early mornings, calloused hands, and a belief that everything he built would one day protect his family. That belief is what his son used against him. Harold had one son, Marcus Bennett, 38 years old, sharp suit, expensive haircut, handshake that felt practiced. The kind of man who had learned very early that charm was a tool and used it on everyone, including his own father. Marcus had married a woman named Diane 3 years ago. And from the moment Diane entered the picture, Harold told me, things started to shift. Slowly at first, then all at once. It started with small things. Diane didn't like Harold coming over unannounced. Then she didn't like Harold coming over at all. Marcus started calling less, visiting less. When Harold did visit, he said he felt like a stranger in a house he had helped furnish. Then came the conversations about money. Marcus approached his father with what he called a family protection plan. He said the business Harold's construction company, valued at over $400,000, should be transferred into Marcus's name for tax protection purposes. Harold was getting older. What if something happened to him? What if the government seized assets? Marcus had a lawyer. He had documents. He had answers for every question Harold asked. Harold trusted him. He signed. 3 months later, Marcus came back. The family home, a 4-bedroom house Harold had paid off, in full needed to be legally secured as well. Same reason. Same smooth explanation. Same stack of documents. Harold signed again. Then the savings account, the investment portfolio, each one transferred, one by one, over the course of 14 months into Marcus's name. Always with a reason, always with paperwork, always with the reassurance that it was all still Harold's, just protected. And Harold believed it, because this was his son, the boy he had taught to ride a bike, the boy he had paid college tuition for, the boy he had bailed out of 2 failed businesses without ever once saying, I told you so. He believed it because he had no reason not to. Until the morning Diane changed the locks. Harold came home from his doctor's appointment to find his key no longer worked. He knocked. He called. Eventually, Marcus came to the door but didn't open it fully. He stood in the gap and told his father, calmly, that Diane needed more space, that it would be better if Harold found somewhere else to stay, just for a while. Harold's bags were already packed. They were on the porch, not inside. On the porch, Harold stood there, 71 years old, a man who had built that house with his own savings, looking at his packed bags on the porch of his own home. He told me he didn't cry, not that day. He said he was too confused to cry. He kept thinking he must have misunderstood something. He hadn't misunderstood anything. He called Marcus 6 times that evening. Marcus picked up on the 6th call and told him it was temporary and that he needed to respect the process. Harold asked where he was supposed to go. Marcus suggested a motel. After 40 years of building, providing, and sacrificing his son, suggested a motel. Harold stayed with his neighbor for 2 weeks before a friend helped him find a legal aid lawyer. That lawyer is the reason Harold Bennett made it into my courtroom. And Marcus Bennett had no idea what was about to happen to him. When Marcus Bennett walked into my courtroom, he walked in like a man who had already decided he was going to win. Posture straight, jacket pressed, a slight smile on his face, the kind that says, I have a good lawyer and I know it. He sat down, adjusted his cufflinks, and looked at his father exactly once. One glance. Then he looked away and didn't look back. I have seen that look before. It is the look of someone who has already rewritten the story in their own head and fully believes the version they invented. I asked Marcus to explain, in his own words, why his father's property was now entirely in his name. He was ready for that question. He leaned forward slightly and said that his father had willingly transferred everything, that it was a planned estate decision made with full understanding to protect the family's assets from probate and taxation. He said Harold had been struggling cognitively for over a year and that the transfers were done for Harold's own protection. I let him finish. Then I turned to Harold. Harold looked at his son for a long moment. Then he said, quietly. I am not cognitively struggling. I run a weekly chess club. I read 2 newspapers a day. And I have never forgotten a single thing my son told me, including every promise he broke. The gallery murmured. Marcus's jaw tightened, just slightly, just enough for me to catch it. I asked Marcus directly, did his father sign those documents voluntarily, with full knowledge of what he was signing? He said, of course, he understood everything. I then asked my clerk to pull up the documents. The business transfer signed 14 months ago, the home deed signed 11 months ago, the savings account reassignment signed 8 months ago. And then the document Marcus was not expecting me to have the investment portfolio transfer signed just 6 weeks ago. I looked at the date on that last document, then I looked at Marcus. Mr. Bennett, 6 weeks ago, your father was still in this process. He shifted in his seat. It was a final step. Everything was planned. I set the document down slowly. Your father filed this lawsuit 4 weeks ago, which means that 2 weeks before he filed, you were still taking things from him. The gallery went quiet. Marcus opened his mouth, closed it, then said, the timing was coincidental. I have heard a lot of things in my courtroom. That was not a sentence I believed for 1 second. I asked Harold if anyone had ever explained to him, in plain language, what exactly he was signing. He said no. He said Marcus always told him it was just paperwork and that he would explain it properly later. Later never came. I asked Harold if he had ever seen a lawyer independently, one not provided by Marcus. He said Marcus had told him it wasn't necessary. I put my pen down. A man signs over his entire life's work based on his son's word alone, with no independent legal counsel, no clear explanation, and no copies for his own records. That is not estate planning. That is a setup. But what I didn't know yet, what nobody in that courtroom knew yet, was that the documents themselves contained something Marcus had never expected anyone to find. The next witness was about to change everything. I had read the case file the night before, thoroughly, the way I always do when something feels deliberate rather than desperate. There was a name near the bottom of Harold's legal aid notes, a witness his lawyer had flagged but not fully developed. I had made a note to call her. Her name was Patricia Odom. She was 64 years old, recently retired, and had worked for 17 years as a notary and legal document processor at the same firm Marcus had used to execute all 4 transfers. She had quit that firm 8 months ago. When Patricia walked into my courtroom, Marcus's lawyer immediately stood up and objected to her testimony as irrelevant. I told him to sit down. He sat down. I asked Patricia to tell me what she knew about the Bennett transactions. She took a breath. Then she said she had processed 2 of the 4 document transfers herself. She said that on both occasions, Harold Bennett had come in alone without Marcus and had appeared visibly confused about what he was signing. She said he had asked her what the documents were for, and that she had told him to ask his son because that was what she had been instructed to tell him. I asked who gave her those instructions. She said, Marcus Bennett, directly. The gallery erupted. I let it run for 3 seconds before I raised my hand. Marcus was already leaning over to his lawyer, whispering rapidly. His earlier composure that polished, practiced calm was starting to crack at the edges. I asked Patricia why she had quit the firm. She said she had raised concerns internally about the Bennett transaction specifically, whether Harold had provided genuine informed consent. She said her concerns were dismissed. She said she was told the transactions were legally sound. She quit shortly after. I looked at Marcus. Your father came in alone, confused, and was told to ask you questions you were never present to answer. You arranged it that way deliberately. Marcus said that was an interpretation. I said, no, Mr. Bennett, that is a witness. I then asked Patricia one final question. I asked whether, in her professional experience, the documents Harold had signed constituted a proper, informed, voluntary transfer of assets. She looked at Harold, and she looked at me. She said, no, in my opinion, they do not. Harold sat very still. He wasn't looking at anyone. He was looking at the table in front of him, and his hands were folded like a man who has just heard confirmed the thing he spent months hoping wasn't true. But even Patricia's testimony, as damaging as it was not the biggest surprise of the day. Because when I asked the bailiff to bring in the next piece of evidence, Diane Bennett, who had been sitting in the gallery the entire morning, stood up and tried to walk out of the courtroom. She didn't make it to the door. Before we go further, where are you watching from right now? Drop your city or country in the comments below. And if you haven't subscribed yet, hit that button, because what Diane tried to hide is something nobody in that courtroom was prepared for. Diane Bennett had been in that gallery for 4 hours. She had sat quietly, arms crossed, face composed. She had watched her husband give testimony. She had watched Patricia Odom speak. And the moment I announced I was calling the next piece of evidence, which, as she would shortly discover, was directly connected to her, she stood up and began walking toward the exit. I said clearly, "Mrs. Bennett, sit down or I will have you removed and held." She stopped, she turned around, she sat back down, but her hands, I noticed, were no longer still. Here is what the evidence showed. 14 months ago, the same week, Harold signed over the business. Marcus had opened a new joint account, not with Harold, with Diane. Into that account, over the following year, Marcus had transferred $91,000 from Harold's liquidated investments and business revenue. $91,000 spent on home renovations, a car lease, 2 international vacations, and a private membership club. Harold's money, Harold's savings, Harold's 40 years, all of it flowing through an account Harold didn't know existed. I set the bank statements on my bench and looked at Marcus. You didn't protect your father's assets. You consumed them. Marcus said nothing. I then turned to Diane. I asked her directly, did she know where the money in that joint account came from? She said she had assumed it was Marcus's business income. I asked her if Marcus had a business. A pause. He had investments. I asked her whose investments. Longer pause. Her lawyer touched her arm. I didn't need her to answer. The statements had already answered, but I waited, because sometimes the silence is the testimony, and then the twist nobody saw coming. Harold's lawyer stood up and asked to introduce one final document. I allowed it. It was a letter written by Marcus, dated 9 months ago, addressed to a real estate developer. In that letter, Marcus had written that his father's property was available for sale and that he was prepared to finalize a deal within 60 days. He had described Harold as no longer a relevant party to the transaction. No longer a relevant party. That is how Marcus Bennett described his living, breathing, perfectly healthy father in a letter to a property developer. Harold heard those words read aloud in the courtroom. He didn't flinch. He didn't cry. He just closed his eyes for a moment, the way people do when something they feared turns out to be exactly as bad as they thought, and then he opened them again and looked straight ahead. I have seen a lot of pain in my courtroom. That moment is one I will not forget. Marcus's lawyer was already requesting a recess. I denied it. We were not stopping. Not now. I want to be clear about what happened before the legal proceedings reached their conclusion, because it matters and because it is the reason Diane Bennett left that courtroom in a very different situation than she entered it. 6 weeks before the court date, Harold had gone back to the house one final time. He had called Marcus in advance. Marcus had told him he could come to collect some personal items, photo albums, some tools, a watch that had belonged to his own father. Harold arrived at the agreed time. Marcus was not there. Diane answered the door. Harold asked if he could come in to collect his things. Diane told him the items had already been dealt with. Harold asked what that meant. Diane told him to leave. Harold said he would wait for Marcus. And Diane struck him across the face. An open-handed slap, full force, against a 71-year-old man standing on the porch of his own house, asking to collect a watch. The neighbor across the street saw it happen. That neighbor was now sitting in my gallery with a written statement. I read the statement aloud. The courtroom was very, very quiet. I looked at Diane. She was sitting with her arms folded, jaw set. The posture of a woman who had decided denial was still a viable strategy. I said, "Mrs. Bennett, you struck an elderly man in the face on property that was fraudulently in your husband's name, and you did it because he asked to collect a watch that belonged to his father. Do you have anything to say?" She said, "He was trespassing." I looked at her for a long moment. He was not trespassing. That was his home. It still is. And you raised your hand against him in it. Now, the ruling, Marcus Bennett had committed financial fraud against an elderly parent. The evidence was comprehensive. 4 fraudulent transfers executed without genuine informed consent, $91,000 moved through an undisclosed joint account, and a letter to a property developer that demonstrated clear intent to permanently remove Harold from his own assets. This was not a misunderstanding. This was a deliberate, sustained, multi-step scheme. I sentenced Marcus Bennett to 1 year in prison, not a fine, not community service, not a suspended sentence with conditions. 1 year, because the law does not offer discounts for betraying the person who raised you. Marcus went white. His lawyer was already talking in his ear, but the words weren't landing. He sat there, suit still pressed, cufflinks still polished, looking at a reality he had genuinely not prepared for. Then I turned to Diane. The assault charge was documented, witnessed, and unambiguous. $5,000 paid directly to Harold Bennett as compensation for the physical and dignitary harm she had caused him. Not to the court, not to a fund, to Harold, in his hand. Diane closed her eyes. And then came the part I had been waiting to deliver since Harold first walked into my courtroom that morning. I ordered every asset returned, the business, the property deed, the savings accounts, the investment portfolio, all of it transferred back to Harold Bennett, legally, cleanly, and immediately. Not eventually, not pending appeal. Immediately, with a court-appointed supervisor to oversee the process and ensure nothing was delayed, hidden, or accidentally lost. The court-appointed administrator would also audit the $91,000 that had passed through the joint account. Whatever remained, and we were going to find out exactly how much remained, would be returned. Harold's name was going back on everything he had built. 40 years of work, returned in a single ruling. Marcus was escorted out. Diane sat alone, and Harold Bennett sat at that plaintiff's table, documents in front of him, his name printed on every single one, and did not move for a long moment. I have delivered a lot of rulings. I have watched defendants leave my courtroom in handcuffs, in tears, in silence, and in rage. I have watched plaintiffs leave with relief, with exhaustion, with quiet satisfaction. What happened in those final minutes of the Harold Bennett case was something I do not see often. As the bailiff moved toward Marcus to escort him out, Marcus stopped walking. He turned and he looked at his father, really looked for what I think may have been the first time that entire morning, and he broke, not dramatically, not with the kind of collapse that performs for an audience. He just broke. The way a man breaks when he finally understands that it is real, all of it, the sentence, the consequences, the magnitude of what he has done, and there is nowhere left to hide from it. His voice came out uneven. Dad, I am sorry. I know that doesn't fix anything. I know it, but I need you to know that I am sorry. Please, please, just please forgive me. The courtroom went completely still. Harold did not look at his son immediately. He gathered his documents slowly, the property deed, the business title, the savings account papers, and he stacked them neatly, the way a careful man handles things that matter. Then he stood. He looked at Marcus for a long time. When he spoke, his voice was steady, not cold, not angry, just steady the way a man speaks when he has already done his grieving in private and what is left is only truth. I prayed for you every morning, Marcus, even after the porch, even after the locks, even after I found out about the letter to the developer. Every morning, I still prayed for you because you are my son. That does not change. Marcus was crying now. But forgiveness is a gift, son, and gifts are given freely, not taken. You spent the last 14 months taking from me. So no, not today, not like this. He paused. When you come out the other side of this, if you decide to become someone different, then we will talk. But I will not hand you my forgiveness the same way I handed you my house, because look where that got me. He picked up his documents. He walked out, not quickly, not slowly, the way a man walks when he knows exactly where he is going and has no reason to rush. The gallery was silent for a full 3 seconds after he left. Marcus was still standing there when the bailiff touched his arm. He let himself be guided out. Diane sat alone at the defendant's table, staring at the wall, $5,000 fine written on the paper in front of her. I sat for a moment before I called the next case. I have been asked many times over the years what I think makes a person capable of doing what Marcus Bennett did to his father. The answer, in my experience, is not that complicated. It is not a mystery. It is entitlement. plain and simple. The belief, deep, practiced, unexamined, that the people who love you most are resources rather than people, that their sacrifice is your inheritance and their trust is your leverage. Marcus Bennett did not wake up one morning and decide to destroy his father. He built toward it slowly, one small justification at a time, until the whole structure was in place and the only thing left was to walk away from the rubble. And Harold Bennett, who built an actual business with actual hands and actual sweat, rebuilt himself too. Not from rubble, from truth. He walked into my courtroom that morning with nothing but a neighbor's couch and a legal aid file. He walked out with his name back on everything he had earned. That is not a small thing. That is a man's life returned to him. The law cannot undo the 14 months. It cannot give back the morning he stood on that porch. It cannot restore the conversations that didn't happen, the trust that was methodically dismantled, or the quiet devastation of realizing your own child saw you as a balance sheet. But it can put his name back on his front door. And today, it did. Marcus Bennett, 1 year. Diane Bennett, $5,000. Harold Bennett, everything that was always his. Some debts cannot be repaid, but some things with the right amount of truth and the right judge can be restored.